And so good morning again, everyone. Welcome to the August 1st meeting for the Criminal Justice Coordinating Council. I have 8:02 on my clock, so I'm going to call this meeting to order. The agenda and the minutes were sent to you all previously for review. Are there any corrections, additions, or deletions? Okay, seeing none, I see that there's no changes or additions. I don't see any hands up, so we're going to go ahead and approve the agenda and the minutes by unanimous consent. Today we have new business. We're going to have a overview of the juvenile law and prosecution by Joanna Petros, the chief of the juvenile unit for the Anne Arundel County State's Attorney's Office. Then we'll have a presentation from the Anne Arundel County Police Department, Captain Elizabeth Smith from the Community Relations Division. And then we'll have some updates to the juvenile detention in Maryland and Anne Arundel County from Christopher Klein. Full transparency, I did reach out to the Office of the Office of the Public Defender's Office. I did not hear back from them, so I'm going to hope to get in contact with them to have them come to our October meeting. But I want to let you all know that I did, in fact, reach out to OPD just to make sure they're also present and a part of this conversation as well. So hopefully they'll be at the October meeting. And with that said, we can go ahead and get started. Chief Petros, when you get it, I see.
Okay, good morning, everybody. Thanks for having me. I'm happy to be here to present. I'm going to try to ask for a little of help because I'm not sure how I share my screen so that I can utilize the PowerPoint. Does anybody know how to do that within here?
No problem. Look at the very bottom. There is a rectangle with a arrow
Oh,
in it
shoot.
there.
Mhm. Okay. And let me see if I can. All right. Is everybody able to see that at this point?
It's a little small.
Okay. Sorry, let me see if I can go back and reformat it. How about that way? Does that show up better?
It does, and you can click on the
There
full
you
screen.
go.
You can see it. Thank you.
Okay, so I'm going to jump right in here. As it was already stated, I'm the supervising attorney for the State's Attorney's Office Juvenile Division. I have been with the State's Attorney's Office since 2011 and been within the juvenile department since my oldest was born around 2009, because, as you may or may not know, in juvenile, there are no jury trials. So we don't have to balance that schedule. Everything's a court trial. So for those of you who are not familiar, and just because I think it's always helpful in terms of a background, I'm going to go through the language. I always tell people that the language in juvenile law is unique to it. We are speaking a different language. The words are all different, and I firmly believe that words matter. So we're going to go through them just a little bit. Versus a criminal case, it's not the state of Maryland versus Joe Smith. It's in the matter of Joe Smith. They are not a defendant, they are a respondent. It is not a trial, it's an adjudication. What would be known as sentencing is our disposition. There is no such thing as jail in juvenile court. We have placements, and it would be commitment to the Department of Juvenile Services for either a community or non-community residential placement center. You can also commit someone to a residential treatment center, an RTC, if there's the diagnoses that warrant that. And that's a little bit different of a commitment, but still a commitment. We don't have a no bond or pretrial, pre-sentencing. If somebody is being held prior to their adjudicatory, it is detention at Cheltenham or a like facility. Typically in Anne Arundel County, we see juveniles either be held pre-adjudication at Cheltenham or BCJJC. Is no house arrest, but we do have what's known as community detention with electronic monitoring, or the acronym CDEM. We don't have probation for judgments, but we do have stay of delinquency findings, and a STET is still a STET. So in 2022, the juvenile system had a major overhaul. Our legislature passed the Juvenile Justice Reform Bill. That has gone through a few different variations since its origin in 2002. There have been some updates that are even reflected on this current slide. So the juvenile court was severely limited in 2022. They imposed limitations so under 10 years old, we cannot charge. Police can write a report. They can refer individuals to crisis response, or there's a provision under the law called a SINS petition that can be utilized, but they cannot be cited with a juvenile offense. Whether or not you agree with it, I think that we have a little bit of a gap here, and maybe it's because the SINS petition is intended to fill that. But ideally, I would love to see our state have the ability, and our county have the ability to, when we see kids who are struggling with mental health, even at that young age, even if there's not going to be that charging, the mechanism for the SINS really does need to be improved. I have yet to see a SINS petition be filed in Anne Arundel County, and instead I've seen kids who struggle for years and years and years and really don't get extensive services until they are older and we start seeing them. So under 10 years old, we don't charge. 10 to 12 years old, you can charge if there is a crime of violence, a crime involving a handgun or firearm. And more recently, the legislature added the aggravated animal cruelty and the sex offense in the third degree offenses, because we saw a few matters that were really troubling, and essentially there was nothing that we could do. You have to remember that the aim of juvenile court and the juvenile system versus the adult system is guidance, treatment, and rehabilitation. These are confidential records and proceedings, and it really is those of us who practice it, both on the state side and our counterparts on the public defender side, who handle the majority of our cases, really do believe in the need for services, treatment, so that we can essentially help these kids and not just see them escalate over the years until they turn 18. We have some really great services. I'm always advocating for more. 13 and up, you can charge with any criminal offense. And obviously what this slide indicates is it's not for the 10 to 12 years old, if there is a crime of violence, say a handgun offense or aggravated animal cruelty, then all of the lesser offenses get charged as well. So it's that and any other matters arising from that same is the language within the statute. Automatic adult jurisdiction. I've cited to courts and judicial proceedings, which is the jurisdiction statute where this is all referenced and kept by our legislature. But for a child who is 14 years, essentially that 14 years and older, they can only be charged in adult court if committed by an adult that would be punishable by life imprisonment. So we are talking about that murder in the first degree, rape in the first degree, and the attempts and conspiracies of those, because our law indicates that those are also punishable. The 16 and older is delineated within the statute as to be these offenses that you see: abduction, kidnapping, murder in the second degree, and attempted murder, rape, manslaughter, not involuntary manslaughter. Involuntary manslaughter would still be in juvenile court, even originally charged in juvenile court. Individuals who are charged automatically in adult court, and this is an overgeneralization, but just for purposes of expediency, these 16 and older kids, they're going to be subject to the ability to file for a transfer down. And the statute obviously dictates the factors that the court is going to consider when they evaluate somebody for transfer, and DJS is ordered to complete a transfer investigation. There we are talking about whether or not that child is amenable to treatment in juvenile court. It is very often that those transfer cases do not proceed as contested matters, but are instead resolved with an agreement to transfer down and receive placement at a residential treatment center or at a hardware secure facility, often acknowledging whether or not the child has or hasn't had that opportunity, or at least an extensive opportunity in the past. Again, those of us who practice this really do believe in guidance, treatment, rehabilitation. We do not want to see people simply enter the adult system. We want to see them have the opportunity to receive extensive services. And so juvenile court arguably provides more ability for a child to receive services than adult court. That is the aim under the statute. So these are all the offenses where there's automatic adult jurisdiction and the ability for some of these offenses for the defense to file for a transfer and for a to have the court consider transferring the case down, and DJS to conduct a transfer investigation to see what services they would be amenable to. A juvenile timeline is very, very different from an adult timeline or adult case, and whether it's in district court or circuit court. Anybody who's practiced in district court or circuit court knows that those cases tend to get postponed. It's not uncommon to see a Hicks waiver in an adult case that is serious versus our juvenile cases. Postponements are really not the norm. They are widely disfavored among the bench, and we operate on a much stricter timeline, which I appreciate because the aim is to get services in place quicker and to resolve these matters quicker and not let them languish. So when an officer takes a child into custody, which obviously custody maintains its definition under the case law, and isn't defined under this statute, so that's somewhat of an arguable area, but within 15 days, they're going to file that citation. Our police department has actually moved within recent to an e-citation, which has been extremely helpful in terms of being able to serve these families and get these kids processed with their citation and have these things moving along. So we've continued to move, as many of our court systems have, to more and more of an electronic format. But they file that complaint with the intake officer. Intake officer refers to the Department of Juvenile Services, and the complaint is a juvenile citation, which gives them notice of everything. That is not the charging document in juvenile court. It gives us the ability, in some cases, to file a charging document, which is a juvenile petition filed by the state's attorney's office. Our police department actually has a more than one diversion program as well. I don't know if somebody else is going to speak about those, but whether it's Teen Court or the START program, and whether that's pre-cite or post-cite, because we have ones that are even a diversion program that's pre-citation, but that second subsection of the law leaves that ability for there not to be a speedy trial argument. So again, we can try to treat these kids with diversionary program. We can do these things without having to rush just to cite. After that happens, the respondent is issued those juvenile citations. Will say in a standard felony case within the time period specified, within 15 days of receiving those citations, the department has to make an inquiry. What that inquiry really is talking about is what DJS refers to as their intake unit, and they are supposed to review it to see whether or not they are going to forward it to the state's attorney's office, whether they are going to close it informally with an admonishment, which is like a don't do this again, we don't want to see you again. And oftentimes there are not services attached to that, just the admonishment, or they have an ability to handle it informally, which means that they are not referring to the state's attorney's office, but they are in fact trying to implement or make referrals for services. There's lesser supervision with those type of services. Really, they're just trying to connect the families. They don't have at least from what I have seen over the years, to be candid, the reality is they're really not supervising those informals. It would be incumbent upon the parent and the juvenile, typically, if there are certain conditions that they have to satisfy, to then forward that documentation back to the department. Sometimes the department's going to follow up to the best of their ability, but it's not really it's not as though it's a probation in the same way that we would think of something else. within 30 days of receiving the citations from the Department of Juvenile Services. They forward us those cases that they are not closing. We have 30 days to either file a petition, refer it back to DJS for an informal, or refuse and dismiss the citations. And the refuse and dismiss is really because, interestingly enough, that's the first time when the state's attorney's office receives it, that's the first time that somebody is really looking at it from a lawyer's perspective, somebody with legal training. So there are cases that have been sent to us and we're like, oh my God, this is horrible, but I can't prove this. So if we don't have probable cause, we're still bound by those regulations. Then we're going to dismiss the citation based on insufficient evidence and not file the petition. Or there are cases that sometimes we read notes from DJS and there's a concern about sufficiency of evidence based on who the witnesses are and whether or not they're going to be uncooperative. You might be able to imagine that some of these juvenile matters are interfamily. It's not uncommon to have a kid who struggles with mental health and diagnoses, and then there is an assault within the household. So we want to make sure before we file a juvenile petition, excuse me, in the courts, that we have the ability to go forward. And obviously that sometimes that changes. Somebody's cooperative initially and not later on, but we still try to do our due diligence in each and every case to make sure that the cases that we are charging are viable and appropriate. The adjudicatory hearing in a standard case where the juvenile is not detained occurs within 60 days of service of that petition, either on the juvenile or the entrance of appearance of an attorney. When after the juvenile petition is filed, there is a initial appearance in which they're advised the juvenile and guardian will be served, appear in court. Typically that happens before Magistrate Wolf, and Magistrate Wolf is going to advise them of the fact that they have to get counsel. And that's why a lot of these cases end up with the public defender's office, is because of that requirement of counsel, and they're handed that information immediately. But this is such a specialized area of the law that in some ways that's a real blessing, because the public defenders that we work with get to know these kids and this area of the law just like we do. And not to say I've had several private counsel who have also know this area of the law and do a great job, but it's nice when you're practicing this area of the law with somebody who understands it and knows it, because it is so different. So our adjudicatory hearings happening within 60 days. The juvenile is entitled to a deferred disposition. If they want to proceed to disposition on the same day as the adjudicatory, then we file what's called as a waiver of separate disposition, where they're advised of their right to have a later disposition, but that if they want to proceed, then they're going to file that. Their attorney's going to go over what that means with them. So they're doing all of this knowingly and voluntarily, and we can proceed with disposition same day. That's often the case with a misdemeanor, especially because of the limitations of what the court can and cannot do in terms of disposition, and I will get to that later. And a lot of these juveniles and families don't want to come back another day. If we have a child where there appears to be the need for evaluations, whether that's a social history evaluation or a psychological, then a deferred disposition is often requested by one or both of the parties, and then the court must do a deferred disposition. And so the state can also say, no, I'm not comfortable proceeding with disposition today. I would like a psychological order based on XYZ information that we've come to know. And the court can just will defer disposition and order those evaluations so long as they find that there's also cause for them. Juvenile case timeline for a juvenile that is detained goes even faster. And this can be a whirlwind because, as you might imagine, our detention cases are typically going to be our most serious cases where there is a need, whether that is a armed carjacking and gun possession, whether that is, I've had burglaries of a gun store, where the police ended up pursuing someone in a stolen car, and ultimately, so what ended up being one, and then executing search warrants where more guns were located. And so you can have very complex very serious cases, and the hearing on the petition will be the very next day after they are detained, extended for no more than 5 days upon good cause, but I can't say that I've seen that. The only time where it hasn't been next day is if it falls on a weekend, and then it will happen that Monday. And the adjudicatory hearing is going to be held no later than 30 days after that initial hearing. Disposition is 14 days later. And typically you will see that initial disposition scheduled 14 days later, but it's not realistic to get evaluations back in a 14-day timeline. And so that date would often be postponed to at least a 30-day timeline for disposition. Community detention or detention can be extended in increments not to exceed 14 days. So what that means is we are having review hearings. And while that is, in some cases, good, the problem that we've seen since the legislature enacted these provisions is I've heard from several of my colleagues in the public defender's office and defense counsel counterparts that can be really hard for a child who doesn't understand that they are coming to court and the odds are they're not getting released. So while the intention there is good to review detention and make sure that we should be continuing to hold this child in a serious detention case, they can also be somewhat emotional hearings. So just another factor when you're dealing with kids and very serious cases, and often some situations, whether there's trauma in the background or a dysfunctional household, or et cetera, lack of stable guardian. The adjudicatory or waiver hearing, again, it can be postponed if the court finds extraordinary cause from that 30-day timeline, but we typically try to really adjudicate these within these time constraints, and the court is very strict about that, as they should be. So a child who is alleged to have committed a delinquent act cannot be placed in detention if it's a misdemeanor. The only time that the police can request detention is if it is a felony or a misdemeanor handgun offense. The legislature did add, after 2022, when they revisited these areas of law, other provisions such as number 3, and what they're really trying to aim to tackle here is we've seen a lot of cases that maybe end up being still misdemeanors, but you see a kid who's really spiraling and the need for detention. The department is the only agency that can authorize detention. So the police are reaching out to the Department of Juvenile Services and requesting a detention, that a case proceed as a detention case. And this can be tough too, as you can imagine, because police have other mandates, such as only holding a child for so long under federal law. So this can all be detention cases can often be very tricky, and when detention is sought. We don't see as many detention cases as we used to in more recent history. I can't comment on why, because I'm still seeing serious cases, but a lot of the serious cases that used to be detention cases are now proceeding as standard cases, whether that's, again, a carjacking or a handgun offense. DJS supposedly had a policy that if they were a handgun offense, that they would automatically hold as a detention to make sure that we're not leaving somebody in the community when there are those types of serious charges, and we can really process these cases more quickly and make sure that we're attending to a child's needs very quickly. But as of late, we really have not seen, in this calendar year, we've seen less detention cases than we did in the previous 2 years. So again, the hearing requirement is when you do see a child who is remaining in a facility used for detention, the Department of Juvenile Services is supposed to continue to have those detention hearings and continue to explain. They're supposed to do a report where they indicate what reasons to continue to hold and what the detention alternatives are. So often detention alternatives are going to be to release the child to a different family member's home, maybe on a period of CDEM. And sometimes the court says that's immensely reasonable, and we're going to go ahead and do that and leave the child within the community on CDEM. And in other cases, again, we're going to see that maybe that's not as appropriate, but the department's going to make a recommendation as to what the detention alternatives can be within a report as mandated by the statute. So we talked about in terms of disposition, there's no out-of-home commitment for a misdemeanor offense unless the offense involves a firearm. And that's under our disposition statute, which is Courts and Judicial Proceedings 3-8019. The limits on probation were also imposed in 2022 when the juvenile law was overhauled and revisited. So initially, when they passed in 2022, misdemeanor probation was limited to an initial period of 6 months. They expanded that when they revisited this law, and now it's limited to 1 year. The court can extend probation for good cause. And really, what those extensions are going to be, the good cause is going to be that the conditions of probation are not satisfied. So the child still needs to engage in XYZ and hasn't done that yet. Felony probation is going to be limited to 2 years, and the court can extend probation again in 3-month increments. And again, the reasons for an extension are only going to be if there are conditions of probation that are not satisfied. So it's still a need for probation based on uncompleted conditions of probation. I want to talk a little bit about what we can do in terms of disposition here. So the vast majority of our cases are not commitment cases. They are, in fact, probation cases. And so we are talking about, in the vast majority of our cases, a period of supervised probation with conditions. A standard order of probation is going to include conditions such as obey all laws, attend school regularly, to report to the Department of Juvenile Services before you go out of state, and their supervision conditions. It's also going to include other conditions that we can request customized per the child. So those are often going to include individual counseling, trauma therapy, family functional therapy is very common, anger management, victim awareness courses. Our county fire department has a fire setters course that we found to be really appropriate when there's an arson case or a malicious burning case, and we like to recommend that program. We can also recommend mentor programs, which studies have shown are one of the things that can be most effective. In Anne Arundel County, we've recently started, or DJS has started contracting with a girls group, which a lot of youth really enjoy and find to be beneficial. And then they've also started, and have for quite some time, the Thrive Gun Violence program, where there's supposed to be additional supervision through those types of mentor programs. We can also ask for no contact conditions, stay away conditions, restitution. Restitution is a little bit trickier in juvenile because there is a statutory cap, and also the court is going to consider, in most cases, ability to pay. And when you're talking about a child, that becomes that can become a real limiting factor on a victim collecting restitution in juvenile court. There can also be drug testing and treatment. There's a little bit of a gap here in Anne Arundel County. The only drug treatment provider that we really have is Project Chesapeake. And so it would be great to see additional resources, but that's the vast majority of these cases that have that condition are going to be referred to Project Chesapeake, who the department does contract with. We can add a curfew, or a lot of times the court will discuss the case with the guardian in the courtroom at the time of disposition and ask them, do you have a curfew? And do you want me to incorporate that into the order or indicate that to obey a curfew as directed by their guardian? We can add GPS as a condition of probation, which has its own curfew limitations built in, and also CDEM as well as other conditions. But those are kind of an overview of most of the ones we're looking at. Typically, it's going to be those counseling conditions and those mentor conditions that we find to be the most important and the most needed. The problem with these programs and conditions of probation is that DJS is always in need of more service providers. As of late, we have seen wait lists can be extensive. So it can take a lot of time. And when you only have a juvenile who's on probation for a finite period of time, if it takes them 6 months to get into trauma therapy, then that can be really difficult, both on the family, the child, and all the other parties. Um, Also, we've seen a lot of these services that they're going to operate on a virtual platform, which I hate. As a mother and somebody who's been practicing this area law, I think that what we found after COVID is that kids really didn't respond to virtual services that well, that's not going to be the best way to communicate and reach them. And it's problematic for, in my opinion, that what we see through juvenile court is some of these kids who have diagnoses, whether it's ADHD or something more severe, and we're expecting them to receive these extensive services on a virtual platform. It just doesn't really make sense. So I continue to argue against that on behalf of the state and in hopes that these kids are going to receive the best services that they can. We also have found that programs can often be, in my opinion, way too short. We learned that the department's anger management program initially told it was 2 days and then learned that it was 4 hours, 2 hours on consecutive days virtually. That's not an extensive anger management program. Likewise, the victim awareness course we learned is a 2-hour virtual program. So we would like to see longer programs, better services for these youth who really need them. I mean, we've identified the need, but that's the struggle, and doing the best that we can with the confines that what we have. It's still best to connect them through these probation orders with service providers and do our very best to make sure that they're getting what they need. In Anne Arundel County in 2024, there was over 551 juvenile cases that were petitioned. So far in 2025, we've filed over 260 cases so far, petitioned that many in court. And the other thing that I will say about Anne Arundel County that I think is really great is that both the PD's office as well as the state's attorney's office, we have what's called direct assigned cases, meaning that if a juvenile is on probation and they acquire a new offense, which is forwarded to us for petition, it goes directly to the same attorney who had them on both sides. So we typically try to follow the kids and build a rapport with them, get to know these families, and try to make sure that we're not recommending just the same thing over and over and over and over again. The struggle, like I said, is we only have a finite number of things we can recommend. So that can become the challenge there. So we are on track this year to file a similar number of cases as we did in the previous year. I definitely have not seen a decline in juvenile offenses in Anne Arundel County, and would hope to see that in the future, but that's where we are thus far. I'm trying to think if there's anything that I've missed. But I think that's a quick overview of our juvenile system, our juvenile law, where we are currently, and how Anne Arundel County handles those cases. So.
Thank you so much for your presentation. I'm going to open up the floor now to some questions. I did have one question before I open up the floor. You mentioned that DJS does a transfer services, I think, report. Can you just tell me a little bit more about that? What does that report look like when you're arguing to transfer the juvenile down from circuit court to the juvenile justice system?
So for a case that originates in adult court, once the attorney files for waiver, the court will order the transfer investigation. A transfer investigation is going to be a packet that looks a lot like maybe, I'm trying to liken it to something else, a social history evaluation, if you've ever seen one of those, or a PDI maybe, where they go over prior contacts, prior attempts, whether there has been prior placements or probations. It should lay out that history. And they have said within the more recent years that they don't make recommendations, but they're supposed to be identifying within that transfer investigation what placement options or probation services would be available to the child. The hurdle to that is what we have really seen come out within those contested transfer hearings is that when the department looks to identify a program in juvenile court, they are supposed to sit down and have a meeting. It's called a mass staffing. And they're supposed to be able to actually identify what programs we're going to send this child to based on the offense, whether they need hardware secure, staff secure, or just a community-based program. And they send out application packets. In a transfer investigation, they are looking at all those things and making an educated guess, for lack of a better description, but they haven't sent out any packets. So when they say, okay, we think we would probably, if this child were to be waived down, we would be looking at recommending commitment at a hardware secure facility such as Victor Cullen. We don't know if that program would actually be something that this juvenile would be accepted to or likewise, but they're making those types of recommendations or suggestions within a transfer investigation, and then the court is going to evaluate that. The court is going to look at, sometimes those packets can be helpful because one of the things that you're looking at when you evaluate a child for transfer, when they originate in adult court and you're talking about whether it's appropriate to transfer their case to juvenile court, you're looking at, like I said, the age of the child. You are looking at the offense, and the seriousness of that offense. You are looking at their amenability to services. So that transfer investigation is supposed to give you some idea and some information about what the prior attempts at services were, whether or not they've ever been placed before, like I said, whether or not they went to probation, what probation conditions were not satisfied. Sometimes we find that it doesn't include all the information that we want. Sometimes we find that they are a little bit more robust. It sort of just depends.
Thank you so much. I see you have a hand raised from Pam Brown.
Hello there. Thanks for the presentation. Really good. My agency works specifically with juveniles and with juveniles involved in DJS. We do have a DJS mentoring program that's paid for by DJS, but there are many other diversion programs throughout the county. I think one of the problems is that there is no one agency who corrals those programs so that everybody knows about them. So some of them are underused, some of them are grassroots. For instance, we have a DJS peer navigator that will navigate the DJS kid and their family through services. So I just think that there's sometimes a real lack of information about what's out there, both for the state attorney's office and the police department and everything else. So I was just chatting with Moya in the chat and saying we'll come in October and try and talk about some of those programs so that at least it's, and maybe do some research between now and then about the programs that are actually operating in the community. But I was very interested in what you said about families. In Florida, forever, they have never talked just about SINS kids. They've always talked SINS fins. And we had a SINS fins. I worked in a SINS fins program in Florida, and we had a SINS fins program here in Arundel County. And the fins stands for Family in Need of Services. So clearly, a juvenile in need of services is almost always in a family in need of some sorts of services. And that's what SINS recognizes legally in Florida, but not in Maryland. We lost the funding. That funding was GOCCP. I'd love to bring that program back. Most times, if you serve the family at the same time you serve the child, you solve a whole load of issues. We also have two restorative justice programs. One is community conferencing with the police, and one is school-based community conferencing that diverts before arrest. So I will talk more about that in October, and everybody knows I've talked about this before. But I just wonder how we can link all those things together so that at least we all know what's available and what the entry requirements are, and how we get kids assessed into that programs, because there's no real clearinghouse. There's not an assessment up front that would say, this kid really ought to go into DJS mentoring, or this kid's got a family that really, really needs help economically. So it's a longer conversation, but it's one that we have needed to have for a long time as a group. Adrian's group, Mental Health Services, they give us money to run a cracking mental health program for juveniles. It's a mental health mentoring program. So I think there's certainly the will out there, and there's lots of things out there, but it's not coordinated. So maybe there's a way to have that conversation in October. But thank you for bringing your attention to this, because it's really important. So thank you.
Yeah, absolutely. It absolutely is important. I'm a huge advocate, and some of these programs are more streamlined and they're a little bit more easy to track. The police department has done an amazing job in trying to organize diversion programs and START, which is the pre-charge program, in terms of and placing the child, whether it's in teen court or the community conferencing program. But and that's wonderful to be able to have a pre-site or pre-charge program. I also, in terms of mental health, if you're at all familiar with Steve Thomas in the police department, he's involved in the crisis response team. And I could sing his praises and crisis response praises for a very long time because they're wonderful and they need the type of services where somebody goes out and continues to make contact. What we've seen, what we continue to see is that the struggle with some of this is when you have different sects and different attempts, there's challenges from different ways. So sometimes we have families who come to us and they say, we are exhausted. Okay. People have thrown all this other stuff at us and they operate differently. And we've tried it all. And now I don't want to try anything. And I can't handle this. And then sometimes we see people who are willing and open. So it's going to run the gamut, and not every program is going to be a fit for each different family. And some programs aren't going to be as extensive as what you need for a family. So there are tons of programs where it's like, okay, well, we can connect you with great things, but the child still needs more. So there is a gap. It would be nice if it was organized differently. It's one of the challenges of the juvenile law and the juvenile department is how these cases originate. They are unique in that it doesn't go from police to state's attorney's office to court and then to a supervision agency. DJS is sort of the beginning and the end. And so that can be, while it's aimed to be a benefit, it can also present challenges sometimes in terms of everything. And we still have to track this type of information because we also want to know what hasn't worked, right? And so that's a little bit easier when you have a system where somebody goes from police department to court system to parole and probation, and you can look at records and you can see what's happened. It's harder when you have a juvenile who for years wasn't charged, so crisis was involved as to try to provide services, or they were referred to XYZ program, and their records of those things are really not available to us. And then each and every time you're starting over, which is really difficult for some of these kids to be like, how many evaluations am I going to have? I've been doing this for X number of years. So the intention's there. I wish it was better organized within the law. It's got to continue to evolve. But ultimately, the goals are there. And like I said, the people that really have practiced this and know this area and get to know these children and the struggles within our community, for the most part, I've had some really productive conversations with people who are very passionate on different sides and really do want to see our youth be bettered. It's nice to see some of the programs within the schools too, because sometimes that becomes the first line of eyes or defense, right? You see these kids grow up, and sometimes the people in the schools know best, and know so much about these families that DJS is not going to know yet, or the state's attorney's office is not going to know yet, the PDs are not going to know yet. And so we have also tried to reach out to the school resource officers and different people. It used to be years ago that it was very common to see a DJS agent within the schools and keeping offices there. I can't say that I've seen that as much within recent history. In fact, one of my favorite DJS agents, Shannon Hazard, who is amazing, actually got poached and now works for Anne Arundel County Schools because she was such an asset and so wonderful with these kids within the school system. So you're right, there's a wealth of services. I still think we need more, but
We always need more. We
it
always need more.
would be nice to see them organized and connected in a better way.
But I think the social services piece needs to connect as well. So I talk to families in our cricket teams all the time who say they've had enough of their kids and they're perfectly well-balanced families. But I don't think that's the end of it. I think there's a way to, when we do, I mean, we work with those families as navigators, as friends, with kindness to try to bring that family back together. So I think there's lots of pieces to this, and there's lots of things in Anne Arundel County is putting them together. And certainly this was not any criticism of the police department. We have an excellent relationship with community services and the police department, and they do a fine job of referring out. So none of that. For me, it's how we think of all of it as a universe, and not, here's the state attorney's office, the public defenders, the police, our agency, mental health. How do we talk together about what the continuum of care looks like, so that when we are, we're not moving straight into some sort of prison pipeline, which is what none of us want. And maybe I can invite Delmonica, the regional director for DJS, who is really wonderful, and
I'm
is
very
really trying
familiar with
very hard
Delmonica.
to do a good job with all of
very,
this.
very, very familiar with Delmonica.
Yeah, so
but I
I
also
think
have
she's
to say
part of this
that
meeting. She's just not here today, but maybe if she could come in October, we can really, really thrash this out, and it would be a very, very good use of CJCC time.
some of the other issues, though, is I truly don't believe that DJS the law does not intend it to be, nor is it a pipeline to prison. That's not what commitments are. That's not what services are. This is supposed to be at its core a connection to services. And if you try to keep them out of that for too long, what we see is an escalation. And so you have to balance those things. Not everybody needs to be petitioned, and I'm a huge advocate of that. I tell people all the time, the state's attorney's office does not want every case. Like, that's not what's happening here. But it is not, and nor is it intended to be a pipeline to prison. You need
No,
to
of course not.
connect kids with services at an early age. We have seen kids who have 10 cases get diverted by DJS, and magistrates who are looking at these reports in horror, saying, what are you doing closing 10 cases out informally and not connecting a child with services while they continue to escalate? It's not serving them. So it's not serving our youth. It can be really concerning.
Yep.
Thank you so much. And I do see a hand raised from Judge Stevenson.
Yes, good morning, everybody. Having worked on the juvenile system and now being on the bench and seeing it from I guess from a judicial perspective, I agree wholeheartedly with what Dr. Brown said. It does start with the families. And a lot of these children, you can attempt to take care of the children, but then many of them are being released into the families. So a holistic approach is what works best, because if you're taking these children, you're giving them services and putting them right back into a family that is dysfunctional, then it doesn't help them. So I wholeheartedly agree. FINS, I think that would be an excellent program in order to help. I see it from a different perspective, having family and dealing with families that are divorcing or they're fighting for custody, and see the trauma that these children go to. Many of them end up in the juvenile system because they have families that are not working together. But secondly, what I wanted to say is that I will talk with Judge Crooks, who's the judge in charge of juvenile. And a lot of these services, I'm not sure he's aware of. But I can advocate for him to be here and encourage him to be here in October if Dr. Brown when she does that presentation, because I think it will help us a lot when we're looking at the children, and in order to do when we do the waivers from adult court to juvenile court, if we know that these services are available, this is where we can have our input to be able to say that, okay, these services are here for these families. Let's make sure we incorporate that. So thank you for your presentation.
Thank you, Judge. That'd be fabulous. Thank you very much.
Thank you. I don't see any other hand raises. So thank you again, Joanna Petros, for this presentation. It definitely was a lot of information. Some members of the committee, the commission have asked to have us send that PowerPoint. Can we go ahead and send your PowerPoint to them?
I have no problem with that.
Okay, thank you so much. All righty, and so the next presentation we have is from Captain Smith, and she's going to talk about the updates to their diversion programs. Thank you.
Well, good morning. Thank you so much. And I don't know how I follow that in any manner whatsoever. But I do want to thank Joanna for the the working together aspect of this. They work very closely with our Yes unit, and we're really happy at the collaboration that's happened so far. I also want to give a shout out, thank you to Miss Moya Panda and to the Arundel Stat team, Elizabeth's team. Our collaboration and getting to work together is actually what spearheaded some of these changes. So I'm really excited to kind of take about 5 minutes and show you all today. I am going to try and share my screen. I don't know how that works. Sure, can't share. Let's see if that works. Can you all see that?
We can now, yes.
Awesome. Okay. So again, I'm going to take about 5 minutes to do this, and then I'll be happy to answer any questions that you have. So I had a Arundel stat in, or we had a Arundel stat in to kind of show them our diversion program, but we had already been in the works and talking, and our executive officer, Lieutenant Hightower, couldn't be here today, but he has recommended some changes, and with his assistance and our Yes unit, I will talk to you about those changes today. So first, as far as our diversion programs, none of this will change right here. On the left-hand side, you'll see eligible offenses that we can attempt to divert. And on the right side, you'll see the offenses we cannot attempt to divert. This is not going to change in any manner. And you will also see that the offenses that are the ones that occur the most, you can see on the left-hand side, the assaults, things like that. I do want to point out, we can't really take domestic violence type cases or sex offense cases because those are a little bit more in depth than what we can really do. So our current parameters, what we do right now with our Fresh Start program is we allow kids in for diversion that is no more than 2 prior offenses. They are referred through our reporting system. And then once they get down to our Yes unit and then they look at it, oh yes, they're eligible for diversion, then we get them in and along with their families, and we get them to start and complete. And obviously if they go through and handle everything that they're being assigned, then they will be able to complete the diversion. And then in teen court, we have teen court currently is a post citation, whereas Fresh Start is pre-citation. So right now, teen court allows 0 priors. Obviously, all the citations are screened and they're not forwarded to DJS if they are successfully diverted and handle all of the parameters that teen court sets forth. Both of these programs are amazing. I'm really excited about this next slide. So let's talk about that. So Fresh Start. Fresh Start is actually going to be the same eligible offenses, but we're going to turn that to 0 priors. And as we work through this slide, think about it as a progressive diversion type scenario, if you will. So that way, what we're trying to do is get them into Fresh Start and focus on the problems that are occurring, the problem, not the end result is the crime. What's the problem? What's going on at home? What's going on in the child's life? Are there financial problems? Are there mental health issues? And if so, let's get them referred and diverted over to units or resources that can assist them a little bit more. We would be changing teen court now to be pre and post citation, and they can take up to 2 priors there. So essentially what we are doing is we are saying all eligible offenses that you saw on this slide right here on this left-hand side will now all be referred to our youth engagement services, to our diversion programs. They will screen them, ensure that they are eligible, and then get them either into the teen court program or into the Fresh Start program. Not in that order, I apologize. Fresh Start for 0 and then teen court for up to 2. Again, if they get through those programs successfully, and there are a lot of, if anybody wants more information later, we can kind of go into everything that these programs offer the juveniles, but there are quite a few requirements for these juveniles to graduate from these diversion programs. There's a lot of, there's mental health, there's community service, there's writing essays, and there's just a lot more to it that from the outside you can't really see. And so officers will no longer charge on the offense. They will simply refer it to the juvenile, to our diversion programs. The reason that we are doing this is that we will be able to divert more juveniles in this manner by opening up teen court and making it a progressive diversion. As you can see on the citations here, I'm not going to read it for you, but this is just a 2-month time frame that they pulled from 2024, where you can see that there were 61 citations for a fresh start and 37 for teen court. So that's almost 100 kids in a 2-month time. I'm excited about what this can do for us. And right now, before this change takes effect, we are as standardized as you can be. But the one thing that we really can't take away is how each individual officer handles it. Yes, we standardize it. Yes, they get the standardized training, but now it's going to be the same person or group of people in my diversion program that are going to be able to say, we're diverting this child, they're eligible, let's make it happen. Again, really excited for that. And so some of the pros for this, it's gonna take less time for an officer on the road to get through and complete an incident. This will allow the officer to be more available for other things, as opposed to taking half an hour to write a citation, and then we have to find the parents and get them to sign, and there's just a lot with it. So right now, our YES unit, with the proposed changes, our YES unit is going to be taking the lead on that one. Now, it's not going to take away from an officer's discretion. They can still charge, but what we're going to find is that a lot more juveniles are going to be referred to diversion instead. Another pro here is that a lot of people always ask for statistics, and I don't blame them at all. But now that they're all going through our diversion unit, everything that comes in will be captured by our apricot system. So they will be able to easily query and provide the statistics that a lot of the units have been asking for. And then this new model allows for, a shot at fresh start first. And upon completion of that, it grants them a second chance should there be any recidivism. It also allows for better monitoring of youth who are not eligible for diversion, because what we are going to do if they're not eligible is we're sending mandatory referrals to CIT, which is our crisis intervention. And so that's not going to mandate a youth or a family to talk to CIT, but that's going to mandate somebody from CIT reaching out and saying, hey, can we help you in any manner? Because at some point, normally in diversion, the mental health aspect will be addressed, but if they're not diverted, we can't really address it unless we do this mandatory, like I said, I couldn't think of the name of it. Sorry, everyone. But if we refer them to CIT, if they're not eligible, there's still a shot that we can assist them in some way. And that's about it. I told you I was going to be really short. I don't know if anybody has any questions. I do have Miss Carol here. She's amazing. She's my program manager, and yeah, without her, I'd be lost. So I will open it up to all of you.
Thank you so much. I'm so happy to hear the exciting changes that are coming to the diversion programs offered by the police department. Does any members have any questions? Okay, I don't see any questions at this time. Thank you so much, Captain Smith, for that presentation.
Thank you so much for letting us kind of come in.
No problem at all. And it was definitely, we had a great time coming down to your department to go through all the stats and meeting all the people in your department. So thank you again. Looking forward to seeing what those numbers look like a year from now. Thanks again. All right, the next presentation we have is from Christopher Klein. Thank you.
All right, let me just go ahead and share my screen here. All right, can everybody see that?
Yes, we can see it, but only, I think, half. Okay, yeah, we can see that part.
Okay. So, I heard a lot of great discussion this morning. And I don't want to disagree too much, but I want to sort of provide from my perspective what I see. And some of my slides, I wasn't really sure where I was going to go with this presentation. And I probably have a lot more people on my team that might know a little more of the details. But I really wasn't sure, what I wanted to talk about. But really for me, my struggle is juvenile detention in a system that's designed for adults. And so, I heard the comment earlier, it starts with the juvenile system, and they're at the front end and the back end. And for me, I would love if that was the truth. The reality for me is, in Maryland, we actually see a lot of people come through the adult system first. I've actively been working with Maryland Correctional Administrators Association to try and change the law so that the system is actually people going through the juvenile system first before they come to me. But right now, that's not the system we have. So I want to talk about a couple things here. First of all is the Juvenile Justice and Delinquency Prevention Act, the JJDPA. And that's basically a federal law that's existed since 1974. And it aims to improve the juvenile justice system and protect the youth that are involved in that system. What's interesting is, again, I'm sort of talking about this, from an adult perspective, and the reality is that this is a system that should be the juvenile justice system. So within that act, they created the Office of Juvenile Justice Delinquency Prevention, which they provide funding. I believe Maryland does get that funding, and we are compliant to receive that funding every year. So what's important about this act is in 2018, it was reauthorized. And basically, they look at four components um, in the reauthorization. And one is the deinstitutionalization of status offenders. Two is the sight and sound separation of juveniles from adult institutions, which again, they're talking about a juvenile justice system, but the reality is core component number two is how do we get them out of adult systems? Three, removal of juveniles from adult jails. And I think maybe two, sorry, I might have skipped one. Sight and sound separation from adult institutions. Three, removing them from adult jails. And then four is addressing racial and ethnic disparities. So one important piece about this act is since the reauthorization in 2018, 2025 is the first year that this act is actually being enforced. So they are coming around to states, they are looking at the data, and they are holding states to account for their failures in compliance with this act. So just a snapshot of Maryland. This is actually from GOCAP's data page here. These are just an example of the yearly bookings in Maryland adult jails each year. So in our system, these individuals come through adult jails. This year, we're looking to outpace the previous years. The anomaly year, I think in 2021, where you started to see that decline, my guess is that was somewhat related to COVID. But you can see that these numbers are rising each year. We look to be about 900 and give or take, by the end of this year's reporting. Maryland ranks second, only to Alabama, for the number of teens ages 14 to 7 who are automatically sent to adult court. And so I think Ms. Petros covered a little bit about this. the reality is juvenile court does not have jurisdiction over various age category offenses unless the court waives that jurisdiction transfer back to the juvenile court. So in Maryland, I believe it's a total of 33 crimes that automatically by age and by category come to the adult system. I actually think, and I don't know if this was talked about, and I might be incorrect, but I also believe there's a waiver process for the juvenile court to waive to the adult court. I don't know that we see that very much in the system. Most we see the waivers down to the juvenile court, but that's something that also exists. And then I don't know that this was talked about. In most cases, the waiver can happen down, but there are exclusions. There's actually 3 specific exclusions. One is if the child has previously been transferred from an adult or juvenile court and was adjudicated delinquent, those cases cannot be waived down. If the child was previously convicted in an adult court, those can't be waived down. And if the alleged crime is first-degree murder and the child was 16 or 17 when that was committed, those can't be waived. So those would automatically have to be heard in an adult court system. So for us, the important piece is in compliance with the Juvenile Justice and Delinquency Prevention Act. So there's a requirement, anybody coming into an adult system, that we cannot hold an individual in an adult facility more than 6 hours. So I will say from booking to seeing a commissioner, although we try and expedite those, that's probably about 4 hours on average right there. And then that's for decisions to be made and everything to happen. So by virtue of the 6-hour rule, we are going to be non-compliant every time a juvenile comes into our system for any of those crimes that were listed before. And then the other part of that process is if the court determines that an individual should be held in an adult facility, there has to be a process. So what I have here on this slide is the bench card, which is basically the go-to guide for the judiciary. And this basically says that the court has to fill out this interest of justice form. And that form actually has to be done every 30 days. I believe that the commissioners do not fill out this form. This is done by an actual judge. And so by virtue of that, we're going to surpass this 6-hour time limit. So when the interest of justice form is filled out, they're going to consider factors based on the age of the juvenile, the physical maturity, present mental state, nature and circumstances of the alleged offense, and some other factors. And then this form, which we don't have any control over at the detention center getting it filled out. This form has to be filled out every 30 days. And then the maximum time limit under this act is 180 days in an adult system. So every 30 days, this form has to be filled out. And then after 180 days, if that juvenile is still with us, we're going to be in violation again. So here's a copy. We have worked and talked with the judiciary on making sure that these forms are filled out, that these hearings are happening every 30 days. Again, I think Ms. Petros talked about the challenge of continually having these hearings and juveniles not being released, and the stresses that causes those individuals and families and the system for getting them there. And I do want to say, from the stance of myself and the system and really the administrators across the state, not one of us want juveniles in our system at all. Our systems are not designed for juveniles. We're not set up, and they cause a huge burden on our system when we have them within our facilities. So let's just talk about, I mentioned a little bit about the violations. So every year, I believe every year we're audited. I think GoCap has a member. It just changed. I think it was used to be Bill. Um, I think Miss Crable, I think is her last name, who's now coming out and doing these audits. Maryland has so the federal threshold for violations is 14.6 violations per year, per 100,000 youth in the state. Maryland had 112.34 violations during that period. The failures in Maryland are so drastic that when you look at the national data, they've actually removed Maryland from the stats and made us an outlier, because if our stats were included in those statistics, we would skew all of the other data. So that's how significant the violations are. Based on these violations, we're expected to lose. I think I've seen the numbers between $350,000 and $500,000 in federal funding in the next 2 years. So this has a significant impact on the money that's supposed to go to help, um, you know, build up the juvenile justice system and provide supports and resources. And this is money that we're going to lose because of these violations. The other thing is, when you see these violations, and this is a little pain point for me, but the violations are associated to the Department of Detention. And the reality is, I don't control any, like, I didn't make the laws, and I don't control the judiciary. And all I'm doing is holding the people. And for that matter, I don't control DJS, because when the orders come to take them to DJS, there's a failure for DJS to show up and pick these people up. And that's why I say this system is backward. The system should start with putting them in the juvenile detention center and then figuring out if and when they need to come to the adult system. Then the transfer needs to happen the other way, not the way that it exists in the present system that we have. So we're audited twice a year, or once a year. We also provide data to GoCap twice a year in April and September. What I will say, maybe a shining silver lining for Anne Arundel County, because we have two facilities. Our Ordnance Road Correctional Center is the only facility that I'm aware of in the state that has no violations. But that's simply because we don't book people at Ordnance Road, and we don't ever transfer juveniles there. That's the only way that we're able to not have any violations. But for every other jail across the state, because they book people and they house people, they're going to have violations automatically because the way the system and the laws are set up. So some quick data here. Just in 2024, we had a total of 49 intakes at our facility, and then 2025 year to date, we're 36. So we're probably going to surpass that 49 from last year. And then the breakdown here of the ages, as you can see, most of them, rightfully so, are in those 16, 17, and then those sort of track with some of the mandatory charges that we saw on that other page. Here, and I've sort of mentioned this, the obstacles complying with the law. DJS doesn't accept the juveniles as soon as the placement order is received. The judges are reluctant to do the interest of justice hearings every 30 days. They believe that once it's done, and we should be able to go with the first time it was done if it was completed. And then the compliance monitoring, we've tried to work with GoCap. We tried to work with DJS. Last year, we had a good piece of legislation. DJS threw a wrench in it, in my opinion, in the end, and it went nowhere. And so we're going to be right back in legislative session again, trying to push that these individuals are not ever initially sent through our system. What is good, what I will talk about, Anne Arundel County Department of Detention Facilities, we do have a little bit of a system set up. So the largest challenge, other than the 6-hour time limit and the interest of justice forms, is really keeping juveniles separate from sight and sound in an adult facility that's not designed for juveniles. because we built our central booking facility in 2020, we considered these known factors and took the initiative to build some of this into our system. So we do have a separate booking area just for juveniles where they come in a separate entrance. They're held in separate holding cells. We created shades in the adult side. So when a juvenile is going to see the commissioner or having to move throughout the facility, we have shades that we can pull down from the holding cells that are housing or holding adult offenders. I will say, though, that that's only as good as the circumstance of the juveniles that we have. So as an example, in our holding area, we can hold 4 juveniles. If we have 1 female juvenile and 3 male juveniles, we don't have a system that can hold all of the juveniles, right? If we have 4 juveniles that we have to keep separate because they're co-defendants or they're rivalry gang members, we don't have a system that can hold the juveniles separate. So that's the challenge, is the luxury that we have for adult offenders to be able to move people by classification or keep separates or whatever. We have the full scope of the entire facility. With the juveniles, that doesn't exist. And so then being compliant with sight and sound separation is not a reality for what we can do. We do have a separate juvenile housing area. We can hold up to 10 individuals in that housing area, and that housing area does have a separate outside recreation yard. So if you've read some of the articles here between, I think, 2023 and 2025 related to conditions of confinement and where everybody's automatically in solitary, restrictive housing, part of that's true because the definition of restrictive housing is so broad that any housing situation that is not considered general population is sort of defined under this unrealistic umbrella of what's restrictive housing. But the reality for Anne Arundel County is the housing that we have created for our juveniles is their general population. That's the place where they're going to be the safest. That's the place where they're going to be most successful. That's the place where they're going to be able to receive resources directly to them, which will help them, be safe in an adult facility. It's not realistic that general population for adults is where we're going to place juveniles. We're not going to do it because they're not going to be safe there. They're a vulnerable population, and we're going to do whatever we can do to look out for that population to make sure they're safe. So I think, without going too long, I think that's my last slide. So like I said, we see it from a different perspective. We would like the system to change where we're truly at the back end when it comes to juveniles. And then also that people realize, regardless of what the laws say, if we have somebody in our system, we're always going to look out for their best interests. We do that for any vulnerable population that we have. If it's somebody with mental illness, if it's somebody that's elderly that might have early onset dementia, people with medical infirmities where they have mobility issues, whether it's hearing issues or sight issues. Our system, we take into account all of those things, including juvenile status, and we try and make sure that they're safe. So regardless of whether this law is in place or not, if they're in our system, we're going to do the best we can. But the reality of it is we are an adult system set up to house adults and sort of have a facility that's built on sort of that level playing ground. When juveniles are in that system, it makes it very difficult for us to manage all of those things with that population. So I'll entertain any questions and try and stop sharing my screen here.
Thank you so much for that presentation. Definitely very informative. And I thank you also for being proactive but when building the detention center, having those separate facilities for the juveniles. I mean, you did take my question was what were you going to go back to the legislator to see, you know, if you can get some changes made. Does anybody else have any questions? Is it?
I have one.
Oh, go ahead, Captain.
Mr. Klein, I'd like to agree with you that the juveniles do need to be pulled separate from all adult populations. Because even here in the circuit court, we're limited to 6 hours for them being here. So when they come to court and it gets pushed back or gets delayed, then we're in violation with the state juvenile laws that are in place for us too. So in order to get us out of this hole, I think we definitely need to move forward and start thinking about a separate location just for all juveniles, including housing and courts. I think it all needs to go to one location. That way there's no more issues. Well, I can't say issues, but it'll be better for all the juvenile defenders all around.
Yeah, I totally agree. And actually, I never really thought about the holding at court those potential violations on the court side, people waiting to get to court at the courthouse. So that's a good point.
Thank you. And I have Adrian Mickler.
Yeah, good morning, everyone, and thanks. I just wanted to tell Chris, and I appreciate and recognize the difference and the need for specialization. As you know, when it comes to healthcare, that's kind of a battle we fight all the time. You know, children are not just little adults. There is a difference. The workforce needs are different. The training's different. And I heard Ms. Petros, and I completely agree with. While we have services, we certainly need more of them. And a lot of it boils down to, as we all know, workforce and funding. You know, the specialized workforce that's needed to work with the youth is really getting harder and harder to find. And, I heard her mention coaching. That's kind of where we are. So we're trying to build up that workforce, kind of look at our services, making sure that, they're the best services, the most efficient ones we can bring up. But you make a really good point as how these systems need to work together so that they're not overburdened and you're using resources that aren't really appropriate. And what can we do elsewhere to coordinate? So we do work well with the partnership and DJS and DSS and all those systems to make sure that we try to keep an eye on that. And I also look forward to that October meeting to make sure that we are coordinated. But I certainly appreciate, where you're coming from with the system. We've tried to make the system fit, and what we're finding is it's not a good fit. So what can we do to manage those different challenges?
Thank you. And I see that Joanna has your hand up.
Yes, sorry. I just want to make sure I understand the different. My presentation was largely about juveniles who are charged on a juvenile citation and therefore processed in juvenile court. Am I correct in assuming everybody who you're talking about are really those kids who are automatic adult jurisdiction, who you're talking about the kids who are charged not on a juvenile citation, but to begin in adult court and then subject to that waiver period? I'm just wondering if there was a miscommunication, because when I said things really originate in juvenile court, what I meant was juvenile citations go to Department of Juvenile Services and then to the state if they get referred, and then back to DJS for supervision. It sounds like you're talking about that population of kids who are automatically charged on adult jurisdiction and therefore charged as adults and get processed in the jails. Is that right?
Yeah, that's the group I'm talking about. But I think, I guess in the broader scope, I'm just looking at the juveniles as a whole. So I know the side that you were speaking from for your presentation, but I feel like it's, we're talking about juveniles. We're sort of separating when we should be managing them, I guess, to some degree through the same process, in my opinion. I just feel like, from my perspective, we're holding a bunch of juveniles. So you said like jail, I think in your terminology, right? You say jail isn't a term for juvenile justice. And the reality is, in my world, jail is a term for juvenile justice. And I know that I understand the difference you're making, but the reality is I have juveniles in my jail every day, right? And so because there are certain charges and there are certain ages, we're saying, oh no, we'll put them in the adult system and then figure out how to get them back to the juvenile system. And that happens in a lot of these cases. And I just sit here and wonder, why are we the starting point, right? Why isn't it reversed? Why aren't they going to juvenile system first? And then if we think there's an interest of justice, and then if we think there's all of these needs, why aren't they then trying to figure out how to move them to the adult system? So I hear what you're saying, and I understand where you're presenting it from. I just, in my world, I can't separate to say that juveniles aren't in our system, because they are, and I consider it part of the juvenile justice system as a whole.
No, totally understand, and I appreciate that. I'm not denying at all that there's a population of juveniles who are being treated, at least initially in some cases, and then subject to waiver, or some cases staying up, like the current Howard County case. But juveniles who are being charged as adults. All I meant, and no disrespect, is that a child who is charged on a juvenile, initially cited on a juvenile citation and petitioned in juvenile court, cannot be at disposition ordered to a period of jail. So I am not at all disagreeing or taking issue with what you said. I'm, as a clarifying fact, I was referring to juvenile disposition and not adults.
No, I get it. Yeah, I understand.
Yeah, I'm sorry.
I do. No,
Yeah.
I get it.
Yes, but I understand what you take issue with, and certainly see value in your point. Yes.
Thank you so much for those clarifying comments as well. Any other questions? All right, thank you so much, Chris, for that one presentation. And I'll definitely be following up to see how this session goes, and if you're able to get some laws changed on that end. Do we have any announcements for this meeting? Okay, all right, seeing none. Our next meeting date will be October 3rd of this year. We do have some presentations, as you heard from Pam Brown and the rest of her office lined up. So I'm looking very excited and looking forward to that. I'll also be reaching out to the Office of Public Defender as well to have them join our October meeting as well. All right, so I have 9:29, and at this point, our meeting is adjourned. Oh, okay, I'm sorry, Sandy O'Neill mentioned the Out of Darkness Walk is September 21st at 9 a.m. All righty. Thank you so much. This meeting is now adjourned. We'll see you all in October. Take care. Bye-bye.